Welcome to the deep dive. Today, we're getting into a really interesting court case, Zriek et al. Versus Bank of Montreal from back in 2018.
Yeah, this one's quite the tangle. It basically boils down to whether the Bank of Montreal, BMO, uh, did the right thing or not.
Right, specifically when they paid out two big checks, like $180,000 total.
And the twist is they paid these after they'd already frozen the company's account and refused a whole bunch of other checks.
Okay, let's unpack that a bit. So we have this company, 1716030 Alberta Ltd. They open an account with BMO December 2012.
And almost immediately, there's like a lot of activity. Money in, money out, fast. BMO starts getting a bit, concerned.
Red flags going up.
Definitely.
Yeah.
Then comes a $500,000 check deposit. Big one.
Yeah, okay.
But then, poof, a stop payment gets put on that exact check. So more suspicion.
So BMO's antenna are definitely up by now. Then things really kick off mid-December, right? December 17th.
That's the key date. 16 checks drawn on this BMO account. They all get deposited at various Royal Bank branches.
16. How much are we talking?
Adds up to over $1.3 million. $1,355,000 to be exact. And RBC presents them to BMO for payment. BMO says no. Account's frozen.
And one of those was check number 198 for 90 grand.
Yeah, $90,000 initially. That one becomes important later.
Okay, so BMO freezes the account that same day, December 17th.
Correct. Then just 2 days later, the 19th, RBC tries again with another check. Number 100 for $85,000.
And BMO says...
Same answer. Nope. Account's frozen. Check returned.
Now, crucial detail here. All these checks, the 16 plus the 1, they were all payable to the same entity.
GoldLinkTel. That's right. And here's the kicker. RBC had apparently already advanced funds to GoldLinkTel based on these checks.
Ah, okay. So RBC is potentially on the hook if these checks don't clear.
Exactly. They've already paid out,
Okay.
expecting the funds from BM.
Okay, fast forward a few weeks, January 10th, 2013. What happens?
This is where it gets really contentious. RBC comes back, but this time only with two specific checks. Check hashtag 100, the $85,000 one that was refused before, and check hashtag 198, but now it's for $95,000, not the original $90,000.
Interesting change.
And BMO. This time, BMO pays them. They hand over the money left in the account, about $91,895 to RBC.
Okay, wait. So BMO freezes the account, refuses 17 checks, then turns around and pays two of those same checks later. Why?
Well, that's exactly what the plaintiffs, the company 1716030 Alberta Ltd. and Zriek, wanted to know. They sued BMO.
Oh, is their argument?
Their argument hinged on a piece of legislation, Section 437 of the Bank Act.
Okay, Section 437, what does it say, roughly?
They argued that because RBC had actually started a lawsuit against them and also against BMO by the end of December 2012.
Before BMO paid the two checks in January.
Yes, before. Because of that lawsuit, they claimed RBC counted as some other person making a claim on the money in an action where BMO was also a party.
I see. And according to Section 437, if that happens.
The plaintiffs said BMO needed their consent, the account holder's consent, to pay out the money to RBC.
And they obviously hadn't given consent.
Nope, not given. So they argued BMO acted without authority, acted wrongly.
So the whole case really turned on whether BMO should have honored those two checks in January, given the lawsuit and Section 437.
Precisely. That was the core question for the court.
And what did the court decide? Did they buy the plaintiff's argument about Section 437?
No, they didn't. The court fundamentally disagreed with how the plaintiffs were reading that section.
How so? What was the court's take?
Well, the court pointed out that Section 437 is really designed for situations where there are competing claims on specific deposits. Someone deposits money and then someone else says, hey, that's actually my money.
Right, like a tracing provision, trying to follow specific funds.
Exactly. And in those cases, the bank can either get everyone to agree on who gets it, or they can basically hand the money over to the court to sort out that's called interpleader.
Okay, but how does that apply here?
The court said, look, a check isn't a deposit. It's something different.
What is it then, legally speaking?
It's a bill of exchange. It's basically an instruction, an unconditional order from the account holder.
The plaintiff company in this case.
Telling their bank, BMO, to pay a specific amount to someone else.
To GoldLinkTel, the payee.
Right. The relationship between a bank and its customer is debtor-creditor. The bank owes the customer the money in the account.
So BMO, as the debtor, was just following the creditor's, the plaintiff's, instructions written on the check.
That's the court's view. BMO was obligated to honor its customer's order to pay GoldLink, and RBC received the money simply as the bank for GoldLink.
So the plaintiff's argument about Section 437 making RBC some other person growing the funds, The court felt that missed the point.
Yeah, they felt it misinterpreted what Section 437 is for and ignored the basic legal nature of a check as an order to pay, not a specific deposit being claimed.
Was there any other case law mentioned? I think the outline noted Royal Bank of Canada v. Rastogi.
Ah, yes, Rastogi. That case helped clarify part of Section 437, the part about what happens when the bank is sued.
Section 437 too.
Right. Rastogi confirmed that subsection gives the bank the option to ask the court to decide who gets disputed funds, to interplead, but it doesn't automatically give the person suing any special rights to the money, nor does it tie the court's hands.
So even though RBC had sued, BMO wasn't automatically blocked from paying.
Well, the court in Zriek reasoned that once BMO did pay the checks, as instructed by the plaintiffs, there were no longer any valid competing claims for Section 437 to even apply to. The payment was made according to the drawer's instructions.
Makes sense. So the final verdict?
The court sided with BMO. They granted summary judgment, meaning they decided there wasn't a genuine issue needing a full trial. The plaintiff's case was dismissed.
And what about the other claims they made? Breach of contract, privacy stuff?
All those other claims were kind of tied to the main argument about the checks. Since the core argument failed, those claims essentially fell away too. They weren't pursued further.
So a clear outcome in favor of the bank's actions in this specific, maybe slightly unusual situation.
Pretty clear, yeah. It highlights the difference between how the law sees a check as an instruction versus a deposit.
It definitely gives you something to think about, doesn't it? You know, when you write a check, you expect the bank to pay it.
Exactly.
Hmm.
But this case throws in the complication of, well, what happens when there are legal actions swirling around the account at the same time?
Does this ruling make things clearer for you, the listener, about what banks should do? Or does it maybe raise even more questions about their obligations when things get messy?
Something to chew on, for sure. The intersection of simple banking tools and complex legal fights.